The slaughter, it was the opposite. There's an injunction issued keeping her in place to support under the emergency doctrine, reversed it and ultimately held no. So I have framed this in a way a little different from the cases were, but both of them ultimately end up presenting one of the questions. Does Article 2 of the Constitution require the president to retain the authority to remove somebody without cause? Supreme Court said yes for Ms. Slaughter. You had to be able to remove her without cause, and said no for the Federal Reserve. Fascinating, huh? Let's explore how this came about. The chief wrote both opinions. He wrote the one establishing a general principle in Slaughter, and then he wrote the one giving an exception to the principle in Cook. The majorities who joined him were different in the cases, as you might expect. In Slaughter, he was joined by the other Republican nominees. So you can see the chief there, joined by Justices Alito, Gorsuch, Kavanaugh, Barrett, and Thomas, and all but a little part. And the three Democratic appointees are dissenting. When we get to Cook, you will see that switches. So let's go back, and this is the basic principle. The question, the way our founders of the Constitution answered the question of how to have an effective government, but not a tyrannical government, the separation of powers. And if you think about this, whenever the government acts, if it acts in a way that is lawful rather than lawless, it does so in three different ways. First, some law is enacted. Then there has to be some enforcement of it. That's the executive function. And then the judicial branch decides whether the enforcement is proper. Does the action really fall within the law or not? Those are the three necessary steps. If you act lawlessly, you don't need to follow those steps. If you're a dictator, you can just go and do something, whatever you want. We didn't want that system. We wanted a lawful system. So these are the three parts. And essentially, these cases arose out of the question, okay, so we have these three parts, we have these three separations of power. What happens when the world gets really complicated and we still want to regulate it? Congress isn't really capable of doing that. There are 435 people. They don't function all that well. The idea of Congress actually trying to regulate anything detailed seems not very practicable. The compromise that Congress and the president reached in the early 1900s was creating agencies. There have been some executive agencies, once classically answerable to the president, but there was this idea taken from the Prussians and Germans, those models of administrative efficiency, that if you were to get really smart people, like professionals, true professionals, who knew what they were doing, and you gave them authority, and you protected them from political influence. Because, politicians don't make great, logically reasoned scientific decisions. If you were to set that up, you could actually have a government that worked really, really well. That was the theory. They started acting on it with the Interstate Commerce Commission, and then the Federal Trade Commission, and all of the other commissions, and they had similar models. The models were generally that there would be multiple commissioners, often bipartisan. The president would nominate them, the Senate would have to approve, but they would be protected for a certain length of time and couldn't be fired without cause. They wouldn't serve at the pleasure of the president. They'd only be fired for cause. And then there would be other ways of influence. And so there was this sort of accommodation. And these agencies ended up exercising a mishmash or a combination of all the different things that you need to do to regulate, because that's what you have to do. They're the necessary three parts of having a government. So they would promulgate regulations, which is lawmaking. They would enforce the regulations, which is the executive function. Sometimes they would even adjudicate their own enforcement of their own regulations. And everybody realized this was happening. And the Supreme Court, first in a case called Myers said, no, we don't think you can do that without being removable. Then it changed to Humphrey's executor. Then it followed that for a while, then it walked back. But that was the theory. That's how we got to where we are today. And the majority has disagreed with that theory. And they did so like on a basis that is theoretical and said, if you look at our Constitution, we don't have anything that allows some separate set of organizations, some institution, call it an agency, call it whatever you want, that exercises executive authority without being answerable to the president. Like that just doesn't exist in our Constitution. And so if what's going on is what they're doing is exercising executive authority, they have to be answerable to the president. Imagine for a moment that you were in charge of some really large organization. Like you're in charge of directing it and making sure it's going to. Suppose, say, an organization that had like 2 million employees, which is about the size of the current executive branch. But suppose that there are these people here running large parts of your institution that you couldn't fire. And you said to them, I'd like you to do a certain thing, and they'd say to you respectfully or not so respectfully, no, I'd rather not. What do? That essentially is the pragmatic argument for a unitary executive. It's like in our country, power is justified through democratic support. Right? That's the logic. Why is it legitimate that our government does what it does? It's because we vote for it. But if you have these people who aren't answerable to be voted for, that doesn't feel like democratic power. And by the way, like the idea that people are going to sit there and they're going to act on a purely logical scientific basis and they aren't going to be influenced by who their friends are and their partisans are, doesn't that feel remarkably naive? Do we know anybody who actually acts like that? Not very many. Certainly not the kind of principle you would build a government on. I don't think so. So there's this combination of like political theory of democracy and pragmatic, we don't really think they're acting in that way. And it arrives at this moment, and you have an opinion by the chief saying, no, this whole idea that we're going to have independent agencies that aren't subject to the president's oversight is unconstitutional. Justice Sotomayor, in dissent, writes what I think is one of some of her best work on the court. A very long scholarly opinion that points out that from the very beginning, there has been this pragmatic compromise because we actually needed to govern. And Congress and the president had a discussion over the years about how if you're going to have these agencies that are exercising some legislative function, rulemaking, some executive function forcing, that we're both going to have some influence over there, and they reached this compromise. This kind of worked. But at any rate, they have the power now. The agencies have the power. And now the majority is just going to give it all to the president. Like they actually have the power now. They do make rules. They do enforce them. They do adjudicate them. And now it's the president. In every election, it can go this way and then it can go this way. Like, yes, democratic accountability is one value, but how about continuity? How about stability? How about reliance issues? Like, that seems important to the government too. And who do we think we are, the courts, claiming exclusive authority to draw this balance? The president and Congress have something to say about it. Right? That in sum and substance is the dissent, with some stare decisis added to it. Okay, so that's there. I want to skip right here and end on time. All of this broke down when you got to the Federal Reserve, because here, different majority, look at, there's the chief, but he's joined by the friar dissenters and Kavanaugh, and they say, okay, as much as I talked theory before, let's get real. The monetary supply cannot be subject to political interference. It can't. And because it can't, therefore, you have to protect them from removal. So it has to be for cause. And if the protection is to mean anything, it has to be a substantial for cause. And if the substantial for cause has to mean anything, we have to be able to review it. There has to be judicial review, otherwise it wouldn't mean anything. And for judicial review to be important, we have to be able to issue injunctions enforcing it. And all of this is legitimate because you look back at the first and second federal banks of the United States, and there's enough history to show that even though this looks like executive and the other things, it's an exception, so we'll acknowledge. That's the majority in Trump versus Code. The first one is all theory regardless of consequences. The second one is all consequences regardless of theory. And good luck to you all putting it together. And that is my presentation.
Good afternoon. Thank you so much for sharing your lunch with us, and thanks to Jewel and Aaron and my colleagues for making this possible. So I'm going to continue Aaron's theme discussing presidential power and possible limits on presidential power, but in a slightly different context. I'm going to be discussing learning resources versus Trump, where a 6-3 court struck down President Trump's efforts to impose worldwide tariffs. In this case, raises both a separation of powers question and a statutory interpretation question. And in this case, and this is not uncommon, in this case, it turns out that we have to solve the statutory interpretation problem before we can solve separation of power. So Article 1 of the Constitution, it's the first, creates, empowered, and limits the power of Congress. And Section 8 of that article says these are Congress's enumerated powers, and there's a fairly long list. The first item on that list is that Congress shall have the power to lay and collect taxes, duties, imposts, and excises. And I'll note that everyone in this case agrees that a tariff is a type of tax. Congress has the taxing power under Article 1. Article 2 creates, empowers, and limits the power of the president. And this raises, and sorry about this, this is the Section 2. There's 3 paragraphs in it. And these 3 paragraphs identify stuff that the president can do. If you go through it, you won't see anything about taxes. You won't see anything about tariffs. You'll see, and this is relevant to Aaron's discussion, the president is the chief executive, charged with enforcing the laws, and the unitary executive theory that Aaron talked about is part of that. And it's a way to think about what does it mean for a president to be chief executive. But that's not the power that the president is claiming here. And the existence of this list, and this is actually a shorter list of stuff the president can do than the Article 1 list of stuff that Congress can do. It raises the question, well, can the president do anything that's not on that list? In other words, the question of whether or not the president has any inherent or implied authority. Presidents say yes, 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 yes. Among other things, they say that the chief executive power creates a bundle of powers, that the president is clearly commander-in-chief. That's an express Article 2 power. Presidents often invoke their commander-in-chief power as including lots and lots of other powers. Maybe most famously, and there's lots of famous examples of this, but the Emancipation Proclamation during the middle of the Civil War is an executive order by President Lincoln as commander-in-chief, abolishing slavery for military purposes, meaning it was limited in time and place expressly to releasing enslaved persons in slaveholding states that had rebelled, that had seceded. And it did not release enslaved persons in slaveholding states that did not secede, like Maryland and Delaware. And he said, I realize I'm the president. I realize I have some powers, but not others. As a commander-in-chief, I can justify releasing enslaved persons in areas of rebellion where the folks who are fighting the country, our military enemies, are using enslaved persons as resources, military resources, in a war. It wasn't until the 13th Amendment that slavery was abolished everywhere for all purposes. There it was limited to commander-in-chief power. We don't see that assertion here in this case, because again, Trump was proposing to impose tariffs worldwide against many, many, many countries with whom we are not at war, starting with Canada and Mexico and continuing on.
Yeah.
Many others.
Not at war with yet.
Looking forward to your discussion. All right, so the more broadly you understand, and Aaron alluded to this, the twin purposes of Article 2, more broadly you understand president's inherent power, the more you empower the president to do stuff, and that stuff could be good for security and effectiveness and all sorts of things. But at the same time, when you're empowering the president to do a lot of stuff, you're creating some risks of threats to liberty and invitations to tyranny. And that's, again, is the tightrope to be balanced when we're trying to figure out when, if ever, can the president do stuff that's not explicitly in Article 2. Now, one theory of presidential power, and presidents like this a lot, is that presidential power expands in cases of emergencies. Whether or not that power ever contracts when the emergency recedes remains contested. Another theory of presidential power is that presidential power expands to the extent that it aligns with congressional will, and it contracts to the extent that it is opposed by congressional will. Under this theory, in other words, to the extent that Congress says yes to what the president wants to do, the president is a pretty good separation of powers argument. And to the extent that Congress says no to what the president wants to do, the president is in trouble as a separation of powers problem. So I want to briefly flag the points of agreement and disagreement in this case. Everybody agrees, and you saw it too, that the Constitution gives Congress the power to tax. The text is clear. James Madison wrote about this in Federalist 48. The framers, quote, gave Congress alone access to the pockets of the people. So everybody agrees Article 1 gives that to Congress, and everybody agrees that Article 2 did not give that to the president, at least in peacetime. There's no military issue here. So the president's not any commander-in-chief power. Finally, everybody agreed that Congress could choose to delegate part of its taxing power to the president. And all this case is about is, did Congress do that? Did Congress has the power to delegate its taxing power, at least in part, to the president? Did it do so? And here's the statute that the president enacted in 1977. Congress clearly, go down to the bottom part of that screen, Congress clearly gave the power of the president to do lots of stuff when certain predicate conditions are met. And nobody was fighting, at least in this case, about whether or not those predicate conditions were met. Nobody was disputing President Trump's predicate determination that the opioid crisis and the trade deficit were foreign-based threats to the nation's security and economy. There's a paragraph there. Nor, in this particular case, was anybody fighting about the president's predicate determination that those foreign-based threats rose to the level of national emergencies. And if those two things happen, then the president can do all of the stuff that's on the rest of that page. But what is that stuff? And the sole question there is when Congress gives the president a power, in the case of those foreign-based emergencies, to regulate imports. Does that power to regulate include the power to tax, to impose worldwide tariffs? We get 170 pages of opinions in 7 different opinions. I'm going to give you the nutshell version. 6 justices agree that Congress here does not give the president the power to tax. The power to regulate in this statute does not include the power to tax. They disagreed, though, about whether or not this is regular statutory interpretation. We do this all the time. We interpret the language, and language doesn't include tax. 3 of them. Or whether or not we get there using the major questions doctrine. You may recall that as a doctrine that's emerged in recent years. But the idea is that if the president wants to claim that Congress gave him an extraordinary power, extraordinarily significant power in terms of politics or economics, there's got to be a clear statement that Congress intended to do so. In any event, 6 of them looked at this and said, nope, Congress did not delegate the power to tax. And they were interested in the fact that, among other things, there's a whole lot of verbs in here And if you're going to list a whole lot of verbs and you meant to include tax, why didn't you include tax? If you thought regulate includes tax, why do you have the rest of the verbs? They were also interested in the fact that Congress does know how to do this, that there are other statutes, and maybe we'll talk about them later, other statutes where Congress expressly said, we are giving the president the power to impose tariffs under these limited circumstances. So they know how to do that, they didn't do it here. And they also emphasized the fact that no president in this statute's 50-year history ever understood this to be giving them the power to tax. The three dissenting justices, Kavanaugh, Thomas, and Alito, said they read the statute and they said, we think actually regulate does mean tax. That the fact that it has regulatory goals would be sufficient to understand regulation to include tax. I think the most important takeaway for purposes of today's discussion is that a majority of the court, when given the opportunity to interpret the president's statutory emergency powers broadly, declined to do so under this statute. They did not understand the statute to give the president emergency powers that included worldwide tariffs, which of course is a very substantial power. So, long story short, a reminder when we're thinking about separation of powers that Congress has a huge role to play in empowering or constraining a president. And that courts, too, have a huge role to play in interpreting what Congress did to figure out whether or not Congress did, in fact, empower or constrain the president. The last thing I'll say, a couple of interesting ideas that came up in the various opinions that we're going to get more play going forward. Justice Jackson was in the majority. She wrote a concurrence saying, we all agree, we're just trying to figure out what Congress was trying to do. Did Congress want to give the president taxing power? And she says, and in doing this, and this is not the first time she's done this in a series of cases, she revised a debate that many folks thought Justice Scalia had finished and won. She says, if the question is, did Congress intend to do this? We should look at legislative history. And if you look at the legislative history in this case, she says, Congress said, we're not giving taxing power. That should be an appropriate tool when the threshold question is what Congress intended to do. We'll see how that plays out. And then the other interesting thing is that even among the justices who think that the major questions doctrine is an important doctrine, and that describes at least 5 of them and maybe 6 of them, they wrote 4 separate opinions debating the scope of the major questions doctrine, what it did, and when it should do it, which invites a lot of speculation and uncertainty about whether and when we're going to see the major questions doctrine used in cases.
Thank you so much. I'm going to be speaking today about 2 cases. The first is Childs versus Sal. Sorry, can everybody hear me okay? That's great. Yes. This is a case out of Colorado challenging the application of our state's ban on so-called sexual orientation and gender identity conversion therapy to quote-unquote talk therapy. In an 8-1 decision authored by Justice Gorsuch, with only Justice Jackson dissenting, the Supreme Court held just in March that as applied to licensed therapists engaged, again, solely in talk therapy, Colorado's ban on the practice of LGBTQ conversion therapy for minors was subject to strict constitutional scrutiny under the First Amendment. As you may recall, this difficult standard generally requires the burden on speech to be justified by a compelling government interest and burden as little speech as possible to achieve that interest. So Colorado first banned the practice of attempting to forcibly change a minor's sexual orientation or gender identity in 2019. That ban includes the prohibition on physical aversion techniques, including, for instance, electroshock therapy or the application of other physical stimuli designed to punish or deter same-sex attractions. But it also includes the more common practice of attempting to forcibly change someone's identity via words that can nevertheless inflict intense and long-lasting psychological damages, as many survivors of conversion practices will tell you. Importantly, in its decision, the Supreme Court emphasized that as applied to many forms of conversion practices, including those that involve physical aversion, Colorado's ban was perfectly constitutional, raising no First Amendment speech concerns. That is, the court did not strike down the statute in its entirety, not at all. And even as to the talk therapy at issue in Childs, the court did not rule that the statute was unconstitutional, as some media reports suggested. Rather, the court only concluded that the statute was subject to strict scrutiny review because, in the court's view, the statute was not targeted at professional conduct, but instead, as applied, was targeted at the content and viewpoint of the therapist's speech. Colorado had argued, and the 10th Circuit had agreed, that the law was targeted at professional conduct with only incidental burdens on speech because the law was a regulation of healthcare professionals and their provision of treatment that happened to be provided through words. Laws that target conduct with incidental burdens on speech are generally not subject to strict scrutiny. For Colorado and the 10th Circuit, that the treatment involved words was not in and of itself dispositive of whether strict scrutiny applied, given that much treatment is, as I said, provided through words. But according to the court's interpretation, the statute could be applied to punish the content and viewpoint of the therapist's pure speech, spoken words, regarding sexual orientation and gender identity. Consequently, on remand, the state of Colorado will now be required to demonstrate that the burden on speech is justified by compelling government interest and nearly tailored to that interest. The court remanded to the lower courts for consideration of whether Colorado can satisfy that standard. Historically, the court has recognized that laws protecting people's health and safety are quintessential compelling government interest. Because robust medical evidence exists demonstrating that conversion practices are not effective, that is, people's sexual orientation and gender identity are not susceptible to forced change, and because such practices cause psychological harm because they denigrate people's identity, Colorado may well be well positioned on remand to demonstrate that this statute can withstand strict scrutiny. That said, the decision is yet another setback for LGBTQ rights under the Roberts Court. It represents another example of the court wielding an expansive conception of free speech doctrine to limit, in the First Amendment more broadly, to limit laws seeking to protect LGBTQ individuals, whether it be cake bakers, wedding website designers, or now even healthcare providers carrying the imprimatur of the state in the form of a government-issued license. The court is erecting significant barriers to protecting queer people. And there are more First Amendment disputes on the courts arising, including another case out of Colorado dealing with whether religious schools that accept state funds can nevertheless discriminate against LGBTQ pupils and their families. But the implications of the child's decision will reverberate beyond LGBTQ rights. Many professionals, including healthcare providers, and as you well know, lawyers are regulated via their speech. For example, lawyers can violate malpractice protections and potentially be disbarred if their legal advice, that is their words or pure speech, is wrong and violates government standards. Pursuant to the reasoning of Childs, these kinds of professional regulations could be subject to robust First Amendment scrutiny, potentially imperiling professional regulation in a variety of contexts, including the law, medicine, and finance. In short, the court's decision makes plain that bans on conversion therapy that involve physical practices, conduct, and controversial, but to the extent they are applied to pure speech, they're subject to strict scrutiny. On remand, it may be that lower courts conclude that the weight of medical evidence and survivor testimony indicate that strict scrutiny is met, but in the interim, the Supreme Court has once again indicated that LGBTQ anti-discrimination laws take a backseat to the expressive concerns of those opposing such rights. The second case I'll be discussing is West Virginia versus BPJ, or Pepper Jackson. Together with Little v. Hecox, the decision focused on whether state laws that ban transgender females from participating in female athletics violate Title IX of the Educational Amendments Acts or the Equal Protection Clause. In a decision authored by Justice Kavanaugh, the court concluded that they do not. Starting with Title IX, the court explained that while the statute prohibits sex discrimination by schools receiving federal funds, statute's regulations also authorize separate teams for members of each sex, where selection for such teams is based on a competitive scale, where the activity involves a contact sport. The court noted that since the regulations were issued contemporaneously with the statute and remained consistent over time, all of a sudden regulations are really important. They were especially useful in determining statutes' meaning under law firm. According to the court, the term sex, as used in the statute and regs, cannot plausibly be interpreted to refer to anything other than biological sex, though, interestingly, the court nowhere tells us exactly what biological sex is, that is, what bits and pieces actually matter. The court distinguished its analysis from its recent decision in Bostock versus Clayton County, where the court had concluded that Title VII's prohibition on sex discrimination in employment did include protections for transgender individuals. The court concluded that because Title VII and Title IX govern factually distinct contexts, employment, sports, with Title IX permitting separate teams, Bostock did not govern. With regard to the equal protection claims, the court concluded that by limiting female sports to biological females, the law was indeed drawing sex-based classification, and therefore the law was subject to intermediate scrutiny. Such scrutiny requires the government to justify the classification by an important government interest, and that the line drawn be substantially related to achieving that interest. The court concluded that sex-segregated sports help prevent injuries to quote-unquote biological females and preserves opportunities for them to fairly compete, given what the court characterized as males' quote-unquote undisputed quote inherent physical advantage. Suppose, end quote, the court has never seen me play sports. The court concluded these were important interests and that the line drawn on biological sex substantially furthers those interests. But the plaintiffs raised a narrower equal protection clause argument as well, arguing that while states arguably could limit some transgender females from female sports, they couldn't exclude a subclass of transgender females who had taken puberty blockers or hormones, and therefore narrowed any potential injury or competitive concerns. The court rejected this argument too, concluding this kind of as-applied argument would transform intermediate scrutiny into strict scrutiny by not allowing any sort of governing override. Finally, the plaintiffs also argued that the law discriminated against them on the basis of their transgender status. Here too, the court rejected the argument, concluding in quite a perfunctory way that based on a case called Skinner-Thompson decided a year ago that laws classifying on the basis of the law classifies on the basis of biological sex, not transgender status. The court then continued, saying that even if the law did classify on the basis of transgender status or gender identity, the court had not previously held in such classifications. Was a suspect, noting that 3 members of the court, Barrett, Alito, and Thomas, concluded that such lines should not be subject to heightened scrutiny. But the court refrained from definitively resolving what level of scrutiny applies to transgender classifications. And this is really important for transgender rights going forward, because the court concluded that the laws that didn't create one and in any event, as noted in their sex discrimination analysis, could survive intermediate scrutiny. Importantly, the court did not address and therefore did not rule that states must exclude transgender females from sports under Title IX or the Equal Protection Clause. Finally, Justice Sotomayor, Kagan, and Jackson concurred with the court's conclusion regarding Title IX and dissented with regard to its analysis of the Equal Protection Clause. On the Equal Protection Clause claim, they would have remanded for further fact-finding of whether Becky Pepper Jackson, one of the transgender plaintiffs involved, actually had never experienced endogenous male puberty that created a competitive disadvantage implicating the state's interests. Becky did track and field, discussed the shot, but so injuries were not a concern. She didn't play contact sport. The dissent noted that there were instances in the court's protection sex discrimination cases where the court had concluded that even if the classification furthers the state's interests, most of the time, the state couldn't rely on that classification when it did not further the state's interests, such as when a transgender female did not possess the physical advantages that people assigned male at birth are presumed to have. Through the dissent, the majority was doing the opposite of what they accused the plaintiffs of doing and collapsing intermediate scrutiny with rational basis review and was being appropriate. Thank you.
Okay, before I hand it over to Doug to finish off with threats to democracy and elections, just a brief stopover birthright citizenship, and the Barbara versus Trump case decided on the last day of the term, upholding 14th Amendment's birthright citizenship inclusion of anybody born on U.S. territory, at least those who are the children of either unlawfully present people or lawfully present but temporary non-immigrants, people who might be students, H-1B visa workers, etc. Those two categories were excluded by an executive order written on the first day of the term, protecting the meaning and value of American citizenship. Curiously, the executive order proposed a constitutional interpretation that said that this was the correct constitutional interpretation from 1868 going forward, but that the executive order would only apply prospectively 1 month after the executive order was created. Not clear what the constitutional basis that would have been, but in any case, becomes moot after the case. 5 justices decided that the Constitution, Amendment 14, Section 1, Clause 1, that you have in front of you, includes anybody born on United States territory, at least those who are the children of unlawfully present or temporary non-citizens. The only groups excluded would be the children of foreign diplomats, the children of invading foreign armies, and possibly the children of indigenous people born on indigenous territory underneath the sovereign control of the indigenous tribe. The same 3 exceptions that the Supreme Court noted in 1898. The key interpretive question here is what the phrase "and subject to the jurisdiction thereof" mean. The majority, 5 justices, decided jurisdiction means what the ordinary meaning of jurisdiction means. That is, that the government can exert coercive authority over the individual. Certainly, whether one is unlawfully present or temporarily here in the United States, the government can exert coercive control over that individual. It can apply the criminal laws and the civil laws of the United States against those individuals, and therefore the majority said that is the ordinary understanding of jurisdiction. Historically grounded, coming from English crown rule, was the common law practice in the United States even prior to the 14th Amendment for at least white persons born in the United States, and then thereafter for anybody born in the United States, regardless of skin color. Now, I note that a statutory section here, first enacted in 1940, reenacted in 1952, substantial majorities in Congress in both occasions, both of them postdating the 14th Amendment by 7 and 8 decades, which essentially reenacts the same language in a different form. The following shall be nationals and citizens of the United States at birth, a person born in the United States and subject to the jurisdiction thereof. The reason that's important is the 6th vote against the executive order provided by Justice Kavanaugh was purely on the statutory question, arguing that but it doesn't really matter what the 14th Amendment may or may not have meant, although he offered an opinion that suggested that he agreed with the dissenters' view of the 14th Amendment. He said, we don't need to resolve the constitutional question because Congress has already resolved this. Congress knew that the children of unlawfully present and children of temporary immigrants were being granted citizenship, and they enacted the same provision into law in 1940 and 1942, and therefore no need to go any further than that. Of course, the Kavanaugh opinion would allow for another Congress, this Congress, for example, to consider legislation that would bar the same group that the executive order does, and therefore deny citizenship to a broad swath of the American population, whereas the majority opinion would not allow for that. I'm going to hand it over to Doug. The final thing I'll just say here is that this probably should not have been a case at all. 1898, the Supreme Court resolved this exact question by a larger majority than the Supreme Court resolved it in 2026. Further, as I said, historically, this was the grounded practice of the United States for its entire history, dating back to the English crown. So much so that the history that Justice Thomas offered in his opinion was deemed by Justice Roberts' majority opinion to be, quote, dramatically revisionist. the dissenting opinions attempt to read into the word subject of the jurisdiction thereof a requirement of domicile or a requirement of allegiance, neither of which are textually grounded either in the 14th Amendment or the subsequent congressional statutory authorization. And I should point out, finally, none of the three dissenting justices deal with the fact that Congress, 7 and 8 decades later, reenacted the exact language of the 14th Amendment, knowing full well who was being deemed to be citizens. So that's Barbara versus Trump. I'm going to hand it over to Doug.
All right, you guys have your notebooks out because we have covered a lot of cases. I also wanted to point out, Deep has an article in the current issue of the Yale Law Journal called The Borderline Constitution. If you want to learn a lot more just about this case and so many other areas of law that have been affected by current court and its view about what the borders and what it means to be an American, I highly encourage you. He introduced us, no one got to introduce him, so I thought anything to plug for his really great article and encourage you to read. It is like 300 pages. Let's just see the first 8 and you'll get it. All right, I am going to spend a few minutes talking about election law in this last term. Most of my comments will be about this redistricting case from Louisiana versus LA. I do want to mention briefly at the very end 2 cases because they may be on your mind. I'd like to give you just a few talking points in case things come up in your conversations about these cases. The case from J.D. Vance's campaign that turned into the National Republican Center campaign specifically and explicitly overturned 2 cases from Colorado from the 90s, so it may be relevant. People who may have been in the room during that time, I don't know. And then this Watson versus FEC case is about mail-in ballots, and there's been some activity on the mail-in ballot front this week, so I thought it would be worth highlighting that. But I really want to focus my comments on this first case, Louisiana versus LA. It's a question about the Voting Rights Act, which could be, and maybe should be, a question about broader things. How do we allocate power in the United States? What is the most fair way to allow different groups to have a say in their government? And particularly when it comes to a history of discrimination in this country based on colored people's skin or race. Which is different than if you're a Republican or a Democrat or left-handed or if you cheer for the Bills or the Broncos. There's something specific about that. And it's been a foil for our system of democracy for as long as our country's been around, including in 2026. And the question in Louisiana versus Calais ostensibly was, is the compromise that Congress came up with to deal with this power sharing structure between white and non-white people, is it an okay way for us to operate our country? Does it violate the Constitution? Does it violate ideas of fairness? Is it doing this in the right way? And there are a lot of really interesting and thorny questions that come out of that debate. And ultimately, the Supreme Court said, we think the way that Congress set up the Voting Rights Act violates the Constitution. The remedies that are available under the Voting Rights Act violate the Equal Protection Clause. And the Voting Rights Act, they treat it, and I think fairly, like an affirmative action statute. It says if you can show that you've been discriminated against based on your race, we will provide a remedy for you that will give you something you didn't have before. And in employment, that's a little bit more straightforward. We give you the job that you didn't have before, or we give you money. And in the election context, the way that our country has structured this is we draw districts for minority groups, racial minority groups, that gives them a chance to elect candidates of their choice. But that creates an odd system in our government where we have white districts and non-white districts. And some of the people who support the Voting Rights Act would say, yeah, that's a temporary solution. Just like it's a temporary solution to give preference to people getting into college, extra points for being of a particular racial group. But at some point, we'll reach parity and then we'll go back to a world we don't need that. And it's not really clear in the Voting Rights Act context how temporary this really is going to be, whether the best solution in our country is to just have these racially disparate districts. So the question that came up from this case was, is the remedy provided for winning a Voting Rights Act case a violation of the Constitution? It's not the first time the court has heard this case, but in this particular case, the Supreme Court said, yes, it does violate the Constitution to draw a district that gives, in this particular group in Louisiana, Black voters, African American voters, specific opportunities to elect candidates of their choice. They're thinking about race. Now, the questions that I think we could teach a whole seminar on this particular case because it raises all kinds of deep philosophical questions. What's the best way for white and non-white people to share power in a democracy that is multiracial? We live in a country where we don't have a national ethnicity. Is it possible to solve race discrimination without thinking about race? This is a debate we've seen over and over in the Supreme Court. Pretend like race doesn't exist, but let's cross our fingers that the solution you've come up with will solve the problem we won't name. How much authority does Congress have? Why doesn't the court defer to Congress? The 15th Amendment says don't discriminate based on race, and Congress gets to enforce it. Congress did enforce it in the Voting Rights Act. Why does the Supreme Court get to say that they exceeded their authority? And then is compliance with the Congressional Act a compelling state interest? It could be the case that you're drawing a district, you're thinking about race, you want to draw a district in Louisiana to give Black voters power, and so you acknowledge, yes, of course I'm thinking about race. So strict scrutiny applies. What's my compelling state interest? I'm complying with the Voting Rights Act. Congress gave me this statute. So all of these questions are deep. I don't think they're settled. I think reasonable people can debate and come to different conclusions. But this isn't really what this case was about. It really was not about how to allocate power. It was about whether the Supreme Court had final say in the Voting Rights Act. I think what I want to focus the next few minutes on is the challenge that I'm going to face in 3 weeks teaching this case to students in my election law class at CU. And so there's very predictable disagreement about this. There are people who say, well, this is anti-subordination is the way we should view the 14th Amendment and not this other way. Affirmative action should be seen this way. And liberals don't like it because they think it might hurt the Democrats. Republicans love it because they think, oh, we're getting extra seats. All that stuff's predictable and political, and you'll understand that. But some of the more controversial parts of the opinion are not in just the actual substance itself, the way this case came about. So one, I'll point is to the history. As part of this case, the Supreme Court said to win a Voting Rights Act case, you have to prove that the state intentionally discriminated against you because of the color of your skin or your race or ethnicity. The Voting Rights Act was passed in 1965, and in 1980, the Supreme Court held this exact thing. In order to win, you have to prove that the state was targeting you because of your race. And Congress immediately overturned that interpretation. They issued an amendment to the VRA, and they said, we are overturning a Supreme Court case that interpreted the VRA in a way we don't want them to. And so in 1982, Congress passes amendments to the Voting Rights Act that says you can win as long as you show that the state drew districts in a way that screwed you over. Whether or not they intended to or not doesn't matter. You haven't had political power in the past, we're going to give you an opportunity to have political power in the future. And then in 2026, the Supreme Court said, we're looking at this, and actually we think that you're required to have intent. But there's kind of this interesting history where we've gone through this already, Congress has responded, and it's not clear now. What if Congress responds again and revises the Voting Rights Act again? Will that solve the issue? It didn't seem to solve it for this court in 1982. So that's one part. Relatedly, but complicating this, is the precedent of the Supreme Court itself. So the Supreme Court heard challenges to that very amendment in 1982. The first case was a case called Thornburg versus Jingles in 1986. And they said, oh, of course we accept the results test. It's Congress's purview. And then just 3 years ago, the Supreme Court took a case from Alabama with the exact same facts. The facts on the ground in the Alabama case are almost identical to Louisiana. And they said, the court has long recognized, and all members of the court today agree, that the test of the Voting Rights Act, Section 2, is an effects test, not an intent test. That was the same 9 justices 3 years ago. And so now we have the Supreme Court reversing not just the Supreme Court, but themselves. And as it's small, so it may be hard for you to see, but this is just a screenshot of a footnote from the dissent that says, hey, the majority says that this new intent test is congruent with what we did 3 years ago, but I give you an invitation. Go read the decision and find out for yourself. And since I don't have a lot of time, I'll invite you to do the same, to read Allen versus Milligan and figure out how does this work with what happened in 2026. Regardless of the big thorny questions, if you tell me in 2023 that the Voting Rights Act is an affirmative action statute based on results, and we all agree, all members of this court agree, according to Kavanaugh in 2023, what happens in 2026? And I can't even tell you as a law professor, well, I hate to admit this, but the people on the court changed, which is what I have to kind of tell students when I'm explaining Brown versus Board of Education versus other cases, or different times the court's overturned itself. Something else happened in those 3 years, and it's not completely obvious how to explain that to budding attorneys. So that's one of the controversies. Then there's an issue about timing. There's something you may have read about called the Purcell principle. There's a case, Purcell versus Gonzalez. The Supreme Court says, we will not allow courts to step in and muddle with election rules right before an election. It's not fair. It doesn't give states the ability to respond, and voters might get confused. Again, this 2023 case, in February, the court released an opinion in 2022 before they actually held on the merits. And they said, we're really getting close to an election. We're not going to allow Alabama to change their districts in February because it would be too close to the election. And we don't want anyone to get confused. And so they allowed a map that the next year they affirmed was a violation of the Voting Rights Act. It was diluting the votes of Black voters to stand for an election in the name of fairness. This opinion in 2026, Calais, was issued on April 29th, and the Supreme Court said, you know what, we're not that close to an election, go nuts. And Louisiana did. They got rid of their new remedial district and a district that had already existed that was performing for Black voters, which is really the big takeaway. Then I'll point out this shift, I think, that's going on in the court about partisan gerrymandering. In 2019, in a case called Rucho versus Common Cause, the Supreme Court said partisan gerrymandering is a problem. It violates democracy. It's not a good thing, but we can't do anything about it. And then they spend 40 pages telling us how to fix it. Get a commission in your state, pass a statute in Congress, amend your state constitution. This is a problem, you need to fix it. We're just not the institution to do it. By 2026, the Supreme Court says partisan gerrymandering is a legitimate state interest, and you have to defer to them. And if they're saying that they're drawing a map to help political groups, then that's a legitimate thing for them to do, and you can't sue them for that. So shifted. It's kind of subtle, but it's actually, I think, becoming less subtle. Here's the last point I'll make about this case. Here's the map. You can see that big purple district that's running up through is District 6. That was the problematic district. The assumption would be that Black voters, pink? All right, it's pink, not purple. Not my glasses. But it's long and skinny. And the concern from the court about long, skinny districts is that you're making an assumption that Black voters who live up in the top left of the state will have the same preferences as Black voters who live down in the center of the state just because they're Black. And that's the problem. That's not a fair assumption to make. And the courts has a problem. But this district actually wasn't drawn particularly to screw over Black voters, and Louisiana acknowledged that. So here's one of the other troubles in explaining this case to students. Here is from the state's own briefing to the court, where they said, look, we have made this district for political reasons. And you'll see underneath the second highlighted version, they're trying to protect Speaker Johnson's district. They don't want him to lose. He's Speaker of the House. It's great for Louisiana. And they drew a district that would save his seat. And they acknowledged that. And also Majority Leader Scalise's seat. He said, we haven't done this. Don't blame us for violating the Voting Rights Act. We're doing this for political reasons. And then the Supreme Court said, we're kind of interested in the Voting Rights Act. We'd love to take this case up. And Louisiana then shows up to the Supreme Court and says, I'm sorry that we really discriminated based on race. We don't think that's a good thing to do. Thank you, Mr. Chief. May it please the court. Race-based districting is contrary to our Constitution, and we should never have done that. And Justice Thomas, first question, and as we know, he doesn't often ask questions, and he came out first and said, why did you change sides? You used to say this was political, and now it's race. So there's something cynical about the history of this case too. And again, this is separate from, I think, a legitimate discussion about how to share political power. This particular case came up in a particular manufactured way. The court did things that seemed to go against their own history and practice in terms of timing. And so that's where I think a lot of the controversy lies, is the way this court came about issuing this case, more than even the substance of the case itself. The Voting Rights Act, not a perfect statute. It existed since 1965. And in my opinion, we have not solved the racism problem in our country. So it's not like the statute was perfect and doing everything great. It wasn't like 50 years later we had solved it. So clearly it's a problem, and the court's acknowledging that. The way they went about it has raised some controversy. I just wanted to put that on the radar. Quickly, in 1 minute each, J.D. Vance was running for the Senate, and he wanted money from the Republican Party, but there was a ban or a limit on how much the political party can spend in coordination with candidates. We used to be really afraid of political parties. In 2000, we had the McCain-Feingold Act, which let's limit what political parties do. They're too powerful. And so if the party wants to spend money on get out the vote campaigns, unlimited amounts of money. If they want to run ads saying Republicans are great or Democrats are great, they can do that. But if the Republican Party spends money on an ad that says vote for J.D. Vance, then they're limited in how much money they can spend because it's coordinated with his campaign. And so it's seen as like an in-kind gift to him. And there's limits on the amount of money you can. And this case is interesting because that limit on party donations was challenged in a case out of Colorado. And the Supreme Court said it's completely fine to limit the parties in that way. We're really worried about corruption. We want to make sure the candidates raise their own money and spend their own money. And the Supreme Court overturned that this term. And they explicitly say we're overturning the Colorado case. And so, what is the big takeaway? Well, one, and this harkens back to what Aaron said at the beginning, they made a distinction between parties and other groups. Other groups still can't give money coordinated with campaigns. And the question is that a principal distinction? Is it a principal distinction to say somebody on the Federal Trade Commission is different than someone on the running monetary policy on Fed? It's a hard gray line to find. And here, parties are different than super PACs and different from nonprofit organizations. But it's not particularly clear exactly why. They're not constitutional entities. That was the way the Supreme Court got around this. They said, we want to give parties power. The ultimate takeaway is, at least right now, the Republican Party is doing much better than the Democratic Party with its finances. The Democratic Party, as of the last time I checked, 48 hours ago, has got less than $15 million in the bank and $18 million in bills. It's not good. Elections coming up for them. Republican Party is doing great. They have a lot more money on hand. So in practice, this could potentially benefit candidates who could tap into that amount of money. The second case has to do with mail-in ballots. Mail-in ballots is an issue that's in the news this week because President Trump has asked the Supreme Court to implement his executive order that's been struck down by the courts. It's a completely separate issue. So actually, the only reason I'm flagging this case is so you'll know, wait, I thought the Supreme Court already ruled on mail-in ballots this term. It's a separate issue. What the Supreme Court ruled in this term already was whether election day has to mean the first Tuesday after the first Monday in November. And if that is what election day means, can you count a mail-in ballot that arrived after election day if it was cast or mailed by election day? And the Supreme Court, in an interesting combination of justices 5-4, Justice Roberts and Justice Barrett wrote the opinion, joined the three liberals to say, yeah, election means when you vote for somebody, not when you count the ballots. In fact, if you had to select the final person, every state would be in violation because nobody certified the winner for months. You got to actually count. Even if I show up and vote on the machine or drop my ballot in, my ballot may not be counted that day. It may not be counted until the next day or the day after by the time it gets taken to the facility and scanned. And so the majority recognized that and said that election equals choice of the candidate. What you're seeing in the news now is that Donald Trump has said, I'm going to prohibit the mail service, USPS, from delivering mail ballots to anybody who doesn't appear on a list that I create, that my administration creates that it says these are only citizens. If your name's on that list, then you don't get your ballot. And that could potentially be a problem because to be on that list, you have to have documents that match your birth certificate. And for a lot of married women, that's going to be a problem. And for a lot of people who are old and who have birth certificates, So it could potentially be a problem, not to mention the question about whether presidents have any say over federal elections. That's the newest emergency kind of quote shadow docket petition from Donald Trump this week. And so it has nothing to do with Watson. So you can remember that, but I wanted to bring up the Watson case because there has been a little bit of attention on the element. Thank you.
Okay, I'm gonna open it up. We have a few minutes left for audience questions. I'm gonna open it up for audience questions. While we're waiting for people to raise their hand, I did want to ask Aaron just very briefly, for the question that Doug sort of teed up. Is there a principal distinction between the governors of the Federal Reserve and any other administrative officer? I mean, who else might fall in there?
Yeah, well, those are two very different questions. Is there a principled basis is one question, and do other people fall within the exception is a different question.
Okay.
The court has said that there may be other exceptions because all sorts of quirky things happen in the government. It turns out that Georgetown is created by Congress as some sort of executive agency. I didn't know that. I have a son right now driving to DC to go to Georgetown. But we were talking deep about history, and the court is diving more into history all the time, and it is not helping make things any clearer. So that the people who thought that history would solve things have turned out to find that history gives more nuance. I think on the question of agencies and different structures, that the more you look at it, the more nuance there is, the more different variations there are, and the more different ways it's been treated over time. The question of whether you're going to continue to allow that nuance or whether you're going to make it more unnuanced or simpler, or where you're going to draw the lines, I think is a very difficult question that neither history nor first principles provides any clear answer to. I don't know if that's just dodging it, but the more I look at it, the more complicated it seems. And we're seeing opinions getting written. You could write opinions in a variety of ways, where if you read them, you'd say, oh, that makes sense. And you'd read a different one, you'd say, that makes sense too. And where does this line fall with agencies and what you have to do? I don't know enough to know.
It's an artful dodge. Thank you. Questions from the audience before I start posing more.
Yeah, why, in regard to the birthright citizenship case, why isn't there more attention, this is how it seems to be, placed on the word nationals? Because we have people in this country who are considered that, like it's on their passports, they're like, we're in American Samoa, but they're like, we're not US citizens, we're US nationals. And I guess I was just wondering why. I get that citizen is in 14th Amendment, but why that doesn't seem to be highlighted more. Like if that's your lead, I don't know if that's how that.
Sure. Just for the people online, the question asked, I'll repeat it, was, as I understand it, why there isn't any emphasis or more emphasis on the word national and nationals of the United States in the Barber versus Trump opinion or the discussion of the case, just so people understand that the basic idea of citizenship, the full membership in the polity, including voting rights, also the privilege of serving on juries, which most citizens attempt to avoid, and to stand for elected office, at least federal elected office, are all some of the duties of citizenship. Nationals is a category of those born on U.S. territory, but not in a place that would automatically confer citizenship. So mostly we're talking about the territorial holdings of the United States. Significant at the turn of the, from the 1800s into the 1900s, but still significant today, as you point out, the Commonwealth of Northern Mariana Islands and other U.S. holdings. Nationals and who can be nationals determined by statute. So if you look at the 8 U.S.C. 1401 through 1409, it has very specific rules about gaining citizenship in various specific territories of the United States. There is a section on Hawaii. There's a section no longer really referring to Hawaii when it was not a state, a section on American Samoa, CNMI, Guam, Saipan, the Virgin Islands, Panama when it was under U.S. military control. Frankly, the reason it's not part of the executive order is because that's not where, at least ideologically, the action is for the president, right? That's not what matters, at least politically, and certainly not numerically either.
Yeah.
Plus, those are statutory questions that Congress can determine, along with some self-determination by people coming from those places. There was actually a popular vote. I'm not an expert on this by any means, but American Samoa, for example, had its own sort of vote on whether.
Yeah, they wanted it.
Yeah, they want, and so there are questions about how to mix their own self-determination, but it wasn't always, it's not, I don't think, unanimous or a consensus view with regards to citizenship from those territories. And then, of course, Congress has significant control over that. The 14th Amendment is not the constitutional question resolved by history, and the 14th Amendment does not actually touch
Those places.
That it's really the mainland rule, not for territorial acquisitions controlled by the United States government. It's a much more complicated question. So,
Thank you. For
other questions? We have a few more minutes.
Quick question. In past seminars on here, Supreme Court cases, there's been a discussion regarding, we've got some justices who are firmly on the so-called left, the liberals and the conservatives, and then discussions on who's kind of, is there movement to the center, or people who are becoming less predictable. And I'd be curious to hear what thoughts any of the panelists may have regarding that.
I've thought. I think that this is, the most conservative court in generations. And while certain members of the court might be more institutionalist than people on the far right, like Justice Alito and Thomas, the degree to which Roberts and Barrett are joining the liberals in liberal victories are cases that should be 9-0, right? But Barber versus Trump is one of them. I mean, this is not a close case. It was a 5-4 decision. So I think that these justices that are, in the middle, certainly they are giving themselves power. By doing so, if you look at the slide that Deep showed, I think Justice Roberts was in the majority 95% of the time, right? So it's quite decisive. But to characterize that as being moderate would, in my view, be sort of ahistorical. It's an extremely conservative court on issues of, as we've just discussed, executive power, individual liberties, almost every issue it's moved to the right, and pretty quickly.
Others? I want to, maybe for Helen and Aaron on the same question, I've heard some law professors suggest that this term might be starting a distinction within executive power cases as between the hypothetical president and then this particular president and this particular president's agenda, which arguably might explain the difference between the ruling in Trump versus Slaughter versus the tariff ruling, right? The tariff ruling is a particularly Trump agenda executive power ruling versus a broader claim of executive power not tied to this particular executive. And so maybe you can offer your own thoughts, but something to respond to.
That's a really good and complicated question. I'll start first by saying I have a little bit different take on the justices. I think Justice Barrett is the most independent thinker on the court. as shown by the fact that she gets ripped by both conservatives and liberals generally politically, and she does things that can't easily be explained by general, like broader brush politics. I think the closest counterpart to her on the other side of the court is Kagan, who is most willing to think and write independently there. So those will be the two things. The chief, I think, is different. I think the chief, no matter who's the chief has to be concerned for the institution. And I think Chief Justice Roberts is pragmatic in a particular way that cares about the institution. And it shows up in the way he assigns cases. It shows up in the way he influences what's granted, and it shows up in the way he chooses what issues to address. But I think that's different. To your question about, are they shaping the institution? I mean, are there specific Trump-only cases or not? I think all of us, I have to confess, there are lots of times I think I'm being completely logical, and it turns out I reflect 20 years or 15 years after the fact. I was not being completely logical.
Okay.
I was being shaped by my broader perceptions of the policy issues. And I have watched that happen in other people. I've watched it happen in myself. I'm not very good at detecting it myself in the moment. And so if you were to look at the court right now and, in these fabulously complex cases with all the history and all the logic and all the everything, are they being affected in what they choose to emphasize by what they think of the policy outcome? The answer is undoubtedly yes, for every single person there, because it's almost inescapable. Which ones are being influenced more and which ones are embracing it more? That's a tougher question to answer. I think some folks, people who are more purely pragmatic in their approach, which I think of Alito as a conservative pragmatist, I think of Sotomayor as a liberal pragmatist, they'll be more open about it. Others try to be more independent, maybe fail, but that's at least what I see going on.
I don't know if this is a variation of what you were talking about, Deep, but I've seen folks recapping the term, suggesting that they think that the conservative majority here is better described as a Reagan court Trump. And I feel that the sample size is too to say. So.
Doug, I'm going to let you have the last word here. The health of our election system going forward and what to look for.
I'm not as alarmist as what I read in the news or even from other law professors that we're not going to have an election in November or that democracy is dead. I think we're in a period of animated discussion as a country about what it means to be an American. And I think that's part of the American experience about being here, is you have a chance to define your own destiny and your own fate. And I think that's true for people who've been in power historically. And I think it's true for people who have been marginalized. I think certain marginalized groups continue to face barriers from society and barriers even from institutions that were set up to help them. And so it's not that we've achieved a place where everybody agrees this is what we wanted America to be like, and we're all happy. But I think part of that consternation, and elections are one part of that, is part of the American dream and the American experiment. So I do think that the mechanics of elections and having someone in power as the president threatening to do things like decertify every voting machine in the country or throw away all the mail-in ballots, I do think that is a threat to having a healthy democracy where elections are free and fair. If we saw what was happening here in other countries and we were election monitors, we would throw up yellow or red flags. We're on a path that's not to a great place. But I also think that we have empowered groups more than in some of those other countries to push back against that still. And so I feel like we're in a place of healthy democratic conversation. even if on the day-to-day, your newsfeed tells you that, you should be terrified of things. Walk outside and breathe some fresh air and talk to your neighbor. Because we live in the greatest country in the world. Our lives are pretty great. Not for everybody. And I get that. I'm speaking from a particular perspective, right? That obviously my life is better than other people in lots of ways. But I do feel like elections in our country are still a platform for people to have a voice, one person, one vote. And that's one of the mechanisms for us to address any of the concerns that you may have felt personally about some of the things you've heard today.
I'm gonna just offer a few concluding thoughts here. One is just for those interested in this type of programming and CLE credits, feel free to go to the Byron White Center website. We do these sorts of programs with CLE credit all the time. Second, a thank you to Bakery Drinker for hosting us. And finally, a big thank you to my co-panelists for all their good.
Thank you all for coming. Thank you, Dr. Bakery. So professional, so kind. Thank you so much for being here. Also, a quick idea during homecoming, October 3rd, we're going to have a CLE, an ethics CLE, which is something that's hard to like. The size is here, together with Monica Shea, and talk about aging, the ethics around aging and people trying to live forever, well, these people, etc. So it should be fascinating. Please come and get to law school. Just have that on your mind and your passions. And also build it back. Yes, and put it in the game right after. Thank you for that kind host and keep going.
Thank you. Thank you.